Hello and welcome to the webinar on GDPR. This webinar, alongside BANT's series of eBlasts on GDPR, is there to support you in implementing and becoming GDPR compliant. As you will all be aware, on the 25th of May 2018, the Data Protection Act will be replaced by the European General Data Protection Regulation, commonly referred to as GDPR. The overriding issue with GDPR is that it gives more rights to individuals in the processing of their personal data. This means that individuals can request access, corrections, and removal of their personal information in ways that weren't available before. There is also a focus on transparency, with privacy notices detailing how data will be used and a requirement for procedures documenting exactly how data will be processed and secured. The new regulation requires clearer evidence of consent from individuals, and some methods of recording consent will no longer be valid. Additionally, GDPR gives greater powers to the ICO, that's the Information Commissioner's Office, to investigate organisations and any reported breaches. We fully understand that getting to grips with GDPR can be daunting and it can be difficult to know where to start. To support you in complying with GDPR, BANT has recently issued guidance notes via a series of eBlasts. Each eBlast covers a different element of GDPR. We would suggest that you work your way through each eBlast and understand the concept and requirements of that one before moving on to the next. This should help you with your familiarity and building your confidence. We will also be putting together and creating a web page with all the relevant information for you to refer back to, as well obviously as this webinar, and we will be putting together an FAQ document of frequently asked queries we're receiving. So within this webinar and BANT guidance notes via the eBlast series, we will be covering Introduction to GDPR, Processing Data, Privacy Notice, Consent, Data Protection Policy, Subject Access Requests, Information Security, and Legitimate Interest Assessment. In addition, BANT has created a number of templates to help you create the documents that you will require in order to be GDPR compliant. These are the GDPR control document, an Excel spreadsheet, privacy notice, consents form, data protection policy, and legitimate interest assessment. In each section, I will explain the technical terms first and then discuss examples where we have them. We will start with an introduction to GDPR, discussing the key elements and the terminology you need to know, understand, and be aware of. In this section, we are going to look at training and awareness, understand what personal data is, what anonymised data is, what pseudonymized data is, key definitions and principles of GDPR. You need to make sure that you and everyone in your organisation, if you work in an organisation, and everyone you work with who handles personal data is aware of GDPR and the changes required. A good introduction to data protection in small healthcare organisations is provided in a 46-minute webinar, The Data Protection of Small Healthcare Organisations, linked to on this slide. All members are encouraged to watch this as part of your GDPR training. The ICO also have an advice service and live chat to help small businesses prepare for GDPR. If you still have questions after reading all the BANT guidance in the eBlast series and also in this webinar, then you can contact the BANT PPC on bantpractice@bant.org.uk. So, what is personal data? Personal data is defined as any information relating to a person who can be identified directly or and indirectly from that data. For example, direct identification includes name, phone number, email, address, date of birth, photographs, and now also includes online identifiers such as IP addresses and cookies. Indirect information might include physical, physiological, genetic, mental, economic, cultural, or social identities that can be linked back to a specific individual. Nutritional therapists process health records, which are classified as sensitive data or special category data, and these are deemed a higher risk than any other personal data. It is therefore essential that you ensure that you have appropriate procedures and technology in place for the processing and securing of this data. GDPR requires you to demonstrate how you will process and document the personal data that you deal with. It is important to understand what anonymized data is and what pseudonymous data is. So anonymized data is data that cannot be traced back to the original individuals in any way at all, either directly or indirectly, but it can still be processed by organizations or individuals to conduct research. Fully anonymized data is not covered by GDPR as it contains no personal information that it needs to protect. Pseudonymization is the processing of data in a way that the data can no longer be linked to a specific data subject without the use of additional information that is held separately. The data is still treated, however, as personal data under GDPR because of the possibility of personal identification. So let's now look at some of the key definitions of GDPR. Understanding these key definitions will help you as you implement GDPR. Data subject. This is a term used to refer to an individual whose personal information is the data in question. Processing. This refers to the collection, storing, and transferring of personal data. Profiling. This is something that is often done by larger organizations and involves automatic processing of personal information to evaluate aspects of the individual behavior and make decisions or take actions. ICO. The Information Commissioner's Officer is the UK's independent authority set to uphold information rights in the public interest. In the Republic of Ireland, the Data Protection Commissioner holds a similar position. Data controller. This is the person within an organisation that decides what data is collected, used for, and who it is shared with. If you are working as a sole practitioner, then this will be you. Data protection officer. This role is required in certain circumstances, such as public authorities and those organisations dealing with large-scale processing of sensitive data. This won't typically apply to nutritional therapists. Data processor. This refers to anyone, sometimes a third-party organisation or business, for example a testing company, who processes data on the instruction of your data controller. Finally, in this section, Introduction to GDPR, we will look at the principles for the processing of personal data. Lawfulness, fairness, and transparency. This covers the primary areas of concern that data should be gathered and used in a way that is legal, fair, and understandable. The public have the right to know what is being gathered and have this corrected or removed. Purpose limitation. Organisations should only use data for a legitimate purpose specified at the time of collection. This data should not be shared with third parties without permission. Data minimisation. The data collected by organisations should be limited only to what is required for the purpose stated. Organisations should not collect data en masse without purpose. And accuracy. The personal data you hold should be accurate, kept up to date, and if it is no longer accurate, should be rectified or erased. Storage limitation. Personal data should only be stored for as long as is necessary. Data can be archived securely and used for research purposes in the future. Where possible, the personally identifiable information should be removed to leave anonymous data. Integrity and confidentiality. Personal data should be held in a safe and secure way that takes reasonable steps to ensure the security of the information and avoid accidental loss, misuse, or destruction. So now we understand the principles of GDPR, key definitions, and the principles for the processing of personal data. We will move on to discuss the processing of data. The first thing you need to know is what personal data you hold and where it came from. This means all personal data, including employees where relevant, and clients. This should be documented, and you must keep records of your different types of processing activity. For example, how you record, store and share personal data for categories of individuals, as we have already said, clients and employees where relevant. You should also record if you share data with any third parties, for example GPs, testing laboratories and supplement companies. BANT has developed an example of the ICO template for the types of personal data that could be held by a typical nutritional therapy business. This template can be found on the BANT website. Please refer to Professional Practice, Guidelines and Tools, GDPR. The examples included on the BANT template spreadsheet should help you to understand how to complete the spreadsheet for your own business. The spreadsheet template includes all types of personal data and special category data, e.g. health and employment records held, associated processing activities, privacy notices, consents, access requests and data breaches. Remember, the spreadsheet is to be completed for categories of data, not individuals. To legally process data under GDPR, you must have a lawful basis for doing so. The template we have just discussed includes a column to identify the lawful basis on which you are processing each type of personal data you have listed. There are 6 different lawful bases available to you. At least one of these must apply whenever you process personal data. So let's now look at the 6 different lawful bases available to you. Firstly, consent. The individual has given clear consent for you to process their personal data for a specific purpose. Contract. The processing is necessary for a contract you have with the individual, or because they have asked you to take specific steps before entering into a contract. Legal obligation. The processing is necessary for you to comply with the law, not including contractual obligations. Vital interests. The processing is necessary to protect someone's life. Public task. The processing is necessary for you to perform a task in the public interest or for your official functions, and the task or function has a clear basis in law. Legitimate interests. The processing is necessary for your legitimate interests or the legitimate interests of a third party, unless there is a good reason to protect the individual's personal data which overrides those legitimate interests. So, you as data controller have deemed it necessary to process the data in order to deliver the service. For example, health data needed as part of an NT consultation, or it is reasonably to be expected as part of the service by the data subject. So, for example, the client expects you to hold the data to be able to do the consultation. There are a number of different criteria that give you the lawful basis to process data, and crucially, different lawful bases give different rights to individuals. For example, if you rely on consent as a lawful basis, individuals have stronger rights to have their data deleted. Processing data for the purposes of legal obligation, contract, vital interests, or public task can be quite clear-cut. However, other lawful bases may be less so. In many cases, you are likely to have a choice between using legitimate interests or consent. If you use legitimate interests as the lawful basis for processing the data, then you have control over the processing and must demonstrate that it is in line with people's reasonable expectations and that it wouldn't have an unwarranted impact on them. If you do use legitimate interests, then you must do a legitimate interest assessment. This is a type of light touch risk assessment based on the specific context and circumstances. It will help you to ensure that your processing is lawful. If you use consent as the lawful basis for processing the data, then individuals have control over the processing of their data, including changing or deleting it. You will need to keep consent records of when and how consent was obtained and refresh them regularly. We will now look at an NT example for determining lawful bases. An NT wanting to process personal data will need to consider a variety of lawful bases depending on what they want to do with the data. By requesting clients to complete a nutritional therapy questionnaire, you will be receiving and therefore processing a lot of personal data. You may wish to use different parts of the information from the NTQ for different purposes. For example, using the health information as part of the consultation would be a legitimate interest basis, as you need this information for the purposes of the consultation. Using the contact information to send newsletters would be a consent basis, as you would need to seek consent to use this personal data for this reason. An NT and client would both ideally sign a terms of engagement, and hence this is personal data. This is a contract between the client and NT, and therefore the contract basis would be the most relevant lawful basis for the processing of this data. How NTs manage the relationship with supplement and testing companies will affect which lawful basis you will use to process data. For example, if you pass on the client's contact details, only then this could be considered legitimate basis, i.e. it could be reasonably expected that you would do this for the purpose of ordering supplements or tests as part of the consultation. However, you might need consent if you wanted to share special category health data. For example, would your client expect that you would share their data in this way? You should consider which lawful basis best fits the circumstances. You might consider that more than one basis applies, in which case you should identify and document them all from the start. We will now discuss privacy notice. So what is a privacy notice? Being transparent and providing accessible information to individuals about how you will use their personal data is a key element of the General Data Protection Regulation (GDPR). The most common way to provide this information is in a privacy notice. Privacy notice is a general term used to describe all the privacy information that you make available or provide to individuals when you collect information about them. This could and should be through a number of channels which the ICO refers to as a blended approach. Examples of a blended approach include a privacy notice page or a privacy notice document on your website, using website tools such as just-in-time, hover text providing relevant privacy information as the information is being entered, updating the client verbally at the beginning of the initial nutritional therapy consultation and handing them a privacy notice document to take away with them, verbally communicating privacy information over the phone, including a privacy statement in an email when you send a nutritional therapy questionnaire for completion by a client. So, how do you ensure that your clients understand how you will be using their information? You need to give clients a copy of the privacy notice when they sign any consents and the terms of engagement in the initial consultation. This is also a good opportunity to talk through the privacy notice with the client and explain how their information will be used. It is also advised to provide the privacy notice as an attachment or a link when requesting the NTQ to be completed, so that they know before they provide their data how it will be used, possibly with a short explanation in the email. Nutritional therapists need to make sure clients understand their privacy notice. It is not just a case of pointing them to the privacy notice on the website and for them to tick a box to say they have seen it. Privacy notice and fair processing. We have referred earlier to fair processing being a key GDPR principle. Being transparent by providing a privacy notice is an important part of fair processing. You can't be fair if you're not being honest and open about who you are and what you're going to do with the personal data you collect. However, this is only one element of fairness. Providing a privacy notice does not by itself mean that your processing is necessarily fair. You also need to consider the effect of your processing on the individuals concerned. Therefore, the main elements of fairness include using information in a way that people would reasonably expect. For example, it is reasonable to expect that an NT would share contact details with a supplement company for the purposes of ordering supplements for a client, but it might not be expected that you'd share sensitive personal data related to the case. You may want to undertake some research to understand clients' expectations about how their data will be used. Thinking about the impact of your processing. Will it have unjustifiable adverse effects on them? And being transparent and ensuring that people know how their information will be used. This means providing privacy notices or making them available using the most appropriate mechanisms. In a digital context, this can include all the online platforms used to deliver services. What should be covered in a privacy notice? To cover all the elements discussed, you will need to consider the following issues when planning a privacy notice. What information is being collected? Who is collecting it? How is it collected? Why is it being collected? How will it be used? Who will it be shared with? What will be the effect of this on the individuals concerned? Is the intended use likely to cause individuals to object or complain? BANT has drafted an example privacy notice for a typical NT business that can be adapted by members. Please refer to Professional Practice, Guidelines and Tools, GDPR on the BANT website to locate this template. Further information can also be found at the ICO's Privacy Code of Practice. So now let's look at consent and when that might be the most appropriate legal basis to use. Consent is one of the 6 lawful bases that you can use for processing personal data. You need to understand when it is appropriate to use consent as the legal basis and how to obtain, manage and refresh consents. Consent is appropriate if you can offer people real choice and control over how you use their data and want to build their trust and engagement. But if you cannot offer a genuine choice, consent is not appropriate. If you make consent a precondition of a service, it is unlikely to be the most appropriate lawful basis. For example, if you were to ask for consent to share personal data with biochemical testing companies so that you can order a test or receive test results, and this consent was refused, then you wouldn't be able to provide this service to the client. Hence, consent would be deemed to be a precondition of service and therefore not an appropriate lawful basis. It would be more appropriate to use legitimate interest as the legal basis, as biochemical testing is an inherent part of providing nutritional therapy to the client. However, you can offer choice to the client for the sharing of their data with their GP or other healthcare providers, as you can still provide a service if this consent is refused. Typically, as a nutritional therapist, you will be using consent as the legal basis for the following: sharing sensitive personal data with other healthcare providers, for marketing and newsletters, and for the sharing of case histories. Most other activities will be covered by a different legal basis. Seeking consent for the sharing of case histories. As part of fair processing, a client should be given a choice over whether their data is collected for the purpose of sharing case histories. This is important for maintaining trust with your client. Hence, BANT recommends that you seek explicit consent for sharing of clients' case histories. This applies even if you remove the client's name, address, and contact details from the case study. As we discussed earlier, removing these does not anonymize data. So how do you ensure that consent is valid? Consent must be given freely. There needs to have a positive opt-in option, which could include signing a consent statement on a paper form, ticking an opt-in box on paper or electronically, clicking an opt-in button or link online, selecting from equally prominent yes/no options, choosing technical settings or preference dashboard settings, responding to an email requesting consent, answering yes to a clear oral consent request, volunteering optional information for a specific purpose, for example, filling optional fields in a form combined potentially with just-in-time notices, or dropping a business card into a box. Consent requests must be prominent, unbundled from other terms and conditions, concise and easy to understand, and user-friendly. Consent must specifically cover the data controller's name, the purposes of the processing, and the types of processing activity. Explicit consent must be expressly confirmed in words rather than by any other positive action. How should you obtain consent? Make your consent request prominent, concise, separate from other terms and conditions, and easy to understand. You need to include the name of your organisation, the name of any third-party controllers who will rely on the consent, why you want the data, what you will do with it, and that individuals can withdraw consent at any time. You must ask people to actively opt in. Don't choose pre-tick boxes, opt-out boxes, or other default settings. Wherever possible, give separate options to consent to different purposes and different types of processing. You need to manage consents. You must have an effective audit trail of how and when consent was given, so you can provide evidence if challenged. For online consent, you may be able to use an appropriate hash function to support data integrity. If you don't have this functionality, BANT recommends that NTs keep a separate spreadsheet with consent provided against a client's name. It should include who consented, when, how, what, if, and when they withdraw consent, and a link to their signed and dated form that shows that they ticked to provide their consent to the specific processing. If consent was given online, include the data submitted as well as a time stamp to link it to the relevant version of the data capture form. You should consider how often you need to refresh consents. There is no set time limit for this and no set time limit for consent. How long it lasts will depend on the context. You should keep consents under review and refresh them if anything changes. BANT recommends that NTs refresh consents for marketing newsletters every 2 years. This is also a good opportunity to check that you hold the correct information for people. Keeping records up to date is an important part of GDPR. Consents for sharing with other healthcare providers would typically be expected to last the period of the healthcare. You need to make it easy for people to withdraw consent at any time they choose. You can use preference management tools, unsubscribe functionality, or as a minimum, provide an email address. BANT has drafted an example consent template for a typical NT business that can be adapted by members. This is available on the BANT website. And now on to your data protection policy. GDPR requires that the data controller has appropriate data protection policies in place. BANT recommends that small NT businesses have just a single data protection policy that describes at a high level how you comply with GDPR and who is responsible. The data protection policy sets out the NT's procedures for complying with GDPR. It is an internal document that provides evidence of compliance, particularly useful in the event of an investigation by the ICO, for example, as a result of a data breach. It might include sections on type of personal data you hold, responsibilities, recording, storing and securing data, transparency, direct marketing, managing consent, subject access requests, transferring data internationally, managing relationships with third-party controllers, reporting data breaches. BANT has drafted an example data protection policy for a typical NT business that can be adapted by members. It's available on the BANT website. So now we'll move on to look at subject access requests. An individual has the right to receive confirmation that their data is being processed and have access to their personal data and any supplementary information, which should be the information as described in the privacy notice. When they request any information, this is referred to as a subject access request. The GDPR provides the following rights for individuals: the right to be informed, the right of access, the right to rectification, the right to erase, the right to restrict processing, the right to data portability, the right to object, rights in relation to automated decision-making and profiling. The GDPR does not specify how to make a valid request. Therefore, an individual can make a request verbally or in writing and to anyone in your organisation. It does not need to be labelled as a subject access request or refer to GDPR. As long as the individual has asked you to do something that falls within one of the 8 individual rights discussed on the previous slide, then this is a subject access request. You may wish to check with the requester that you have understood their request, as this can help avoid later disputes about how you have interpreted the request. It is also recommended that you keep a log of verbal requests. Can you charge a fee for dealing with subject access requests? you must provide a copy of the information free of charge. However, you can charge a reasonable fee when a request is manifestly unfounded or excessive, particularly if it is repetitive. You may also charge a reasonable fee to comply with requests for further copies of the same information. This does not mean that you can charge for all subsequent access requests. The fee must be based on the administrative costs of providing the information. Information must be provided without delay and at the latest within 1 month of receipt of the request. You will be able to extend the period of compliance by a further 2 months where requests are complex or numerous. If this is the case, you must inform the individual within 1 month of the receipt of the request and explain why the extension is necessary. You must verify the identity of the person making the request using reasonable means. If the request is made electronically, you should provide the information in a commonly used electronic format. Ensure that you transmit the data in a secure manner. Please refer to the extract from the BANT Data Protection Policy template on the subject of subject access requests. Now let's move on to look at information security. The GDPR requires you to process personal data securely. This is not a new data protection obligation. It replaces and mirrors the previous requirement to have appropriate technical and organisational measures under the Data Protection Act 1998. However, the GDPR provides more specifics about what you have to do about the security of your processing and how you should assess your information risk and put appropriate security measures in place. You must have appropriate security to prevent the personal data you hold being accidentally or deliberately compromised. This could be cybersecurity, the protection of your networks and information systems from attack, or physical measures. As well as protecting the way you store and transmit data, your security measures should also seek to ensure confidentiality, integrity, and availability. This means that the data can be accessed, altered, disclosed, or deleted only by those who have been authorized to do so. The data you hold is accurate and complete in relation to why you are processing it, and the data remains accessible and usable, i.e. if personal data is accidentally lost, altered, or destroyed, you should be able to recover it and therefore prevent any damage or distress to the individuals concerned. You need to assess your information risk. The GDPR does not define the security measures that you should have in place. It requires you to have a level of security that is appropriate to the risks presented by your processing. You need to consider this in relation to the state of the art and costs of implementation, as well as the nature, scope, context, and purpose of your processing. So, before deciding what measures are appropriate, you need to assess your information risk. You should review the personal data you hold and the way you use it in order to assess how valuable, sensitive, or confidential it is, as well as the damage or distress that may be caused if the data was compromised. Consider what data your NT business holds and the impact of it if compromised. You might rate as low risk the contact information which you use for ordering supplements, whilst high risk information might be clinical notes and nutritional therapy questionnaires which contain special category health data and would have much higher impact if compromised. You should also take account of factors such as the nature and extent of your organisation's premises and computer systems, the number of staff you have and the extent of their access to personal data, and any personal data held or used by a data processor acting on your behalf. You also need to consider what technical measures you need to take. Technical measures are sometimes thought of as the protection of personal data held in computers and networks. Whilst these are of obvious importance, many security incidences can be due to the theft or loss of equipment, the abandonment of old computers or hard copy records being lost, stolen, or incorrectly disposed of. Technical measures therefore include both physical and computer or IT security. When considering physical security, you should look at factors such as the quality of doors and locks and the protection of your premises by means of alarms, security, or CCTV. How you control access to your premises and how visitors are supervised. How you dispose of any paper and electronic waste, and how you keep IT equipment, particularly mobile devices, secure. In the IT context, technical measures may sometimes be referred to as cyber security. When considering cyber security, you should look at factors such as system security, the security of your network and information systems, including those which process personal data. Data security, the security of the data you hold within your systems, e.g. ensuring appropriate access controls are in place and that data is held securely. Online security, e.g. the security of your website and any other online service or application that you use. And device security, e.g. the security of your mobile phone and tablets. You should consider the following. Your cyber security measures need to be appropriate to the size and use of your network and information systems. You should take into account the state of technological development, but you are also able to consider the costs of implementation. Your security must be appropriate to your business practices. For example, if you work in somebody else's premises or clinic, you need to put measures in place to ensure that this does not compromise your security. And your measures must be appropriate to the nature of the personal data you hold and the harm that might result from any compromise. Your information security will be specific to your particular setup. Greater security should be provided to special category data, which would be deemed high risk. Below is some guidance which will help you when assessing your security measures. Use the checklist in the cybersecurity guide to assess your cybersecurity for things such as firewalls, malware, antivirus, and security settings. Protect your devices with the appropriate security software. Protect data stored in your computers by using strong passwords and encryption. Strong passwords should be changed regularly. A password manager can be used to create and store passwords. There are many password generators. Norton provides a free one. Special category data, i.e. health records, stored on your computer should be further protected by encryption. There is a large number of encryption tools available which can be used to encrypt data locally. It may be easier to encrypt your entire hard disk using system tools. There are various system tools available for Windows users and Mac users. Protect data stored on CDs or USB drives by encryption or password protection and lock away securely when not in use. USB drives can be encrypted using BitLocker and FileVault. Backup data regularly. Ensure the backup drive is encrypted or password protected as above and locked away securely. Check cloud drives used to store personal data, comply with GDPR principles, and meet your security requirements. Services such as Microsoft OneDrive and Dropbox use encryption software to protect files on the web and in transit. Once downloaded to a computer or device, files are decrypted, hence why it is important to separately encrypt your computer hard drive. You may also want to consider two-factor authentication to provide further security for access to special category data on your computer or devices. Check cloud-based services and software comply with GDPR principles and meet your security requirements. These may include appointment calendars, diet plan software and other apps which store personal data. In terms of GDPR, NTs will typically be the data controller and the cloud service provider will be the processor. And hence it is your responsibility to ensure that the service you're using is GDPR compliant and has appropriate security, particularly where special category data is involved. This should involve a contract between the data controller and the processor, which is usually stated in the provider's terms of business. You should include in your privacy notice what cloud-based services you use and for what purpose. For example, we would expect members to review any third-party laboratories' terms of business which they are using. We would expect their terms of business to be on the company's website. If there is anything that is unclear, then to give them a call and to discuss. The terms of business should state how they will be processing the data and complying with GDPR. The terms of business is deemed to be the contract. If you transmit special category data, such as health plans, by email, then you should consider encryption, either of the file attachment or of the whole email. Microsoft Outlook enables emails to be encrypted. However, both you and the person receiving the email must have set up digital IDs first, as explained in the link on the slide. Microsoft will provide an encrypt with password function in the menu. Adobe Acrobat also encrypt PDFs with password. You can also encrypt files separately using an application such as 7-Zip or AXCrypt. You can also use cloud service and provide the client with access to the particular folder so that they can log in and access their files. Any printed documents should be kept in a secure place where unauthorized personnel cannot access them, and they must be shredded when they are no longer needed. Our final section discusses legitimate interest assessment. Legitimate interest is one of the 6 lawful bases for processing personal data, as we discussed earlier in this webinar. The document controller spreadsheet example produced by BANT for a typical NT business identified a number of types of personal data that would use legitimate interest as the lawful basis for processing. Where legitimate interest is used as the lawful basis, it requires a legitimate interest assessment, referred to as an LIA, to justify its use. Legitimate interest is different to other lawful bases as it is not centred around a particular purpose. For example, performing a contract with the individual, complying with a legal obligation, protecting vital interests, or carrying out a public task. And it is not processing that the individual has specifically agreed to, i.e. consent. Legitimate interest is more flexible and could in principle apply to any type of processing for any reasonable purpose. If you are relying on legitimate interest, you need to document your assessment of how it applies to that particular processing and ensure that you can justify your decision if necessary. The key elements of the legitimate interest provision can be broken down into a 3-part test. You must be able to satisfy all 3 parts of the test prior to commencing your processing. Purpose test. Is there a legitimate interest behind the processing? Necessity test. Is the processing necessary for that purpose? Balancing test. Is the legitimate interest overridden by the individual's interests, rights, or freedoms? You need to assess each category of personal data where you have identified legitimate interest as the legal basis against the 3-part test and document the outcome so that you can demonstrate that legitimate interest still applies. This is referred to as a Legitimate Interest Assessment, or LIA. An LIA is a type of light touch risk assessment based on the specific context and circumstances of the processing. You need to record your LIA and the outcome. BANT has drafted an example LIA template for a typical NT business that can be adapted by members. BANT has also produced a completed example for health records and clinical notes. You will need to complete an LIA for each category of personal data that you use legitimate interest as the legal basis. It would be inappropriate to complete this webinar without referring to the cost of non-compliance. Besides the power to impose fines, the Information Commissioner's Office, ICO, has a range of corrective powers and sanctions to enforce the GDPR. These include issuing warnings and reprimands, imposing a temporary or permanent ban on data processing, ordering the rectification, restriction or erasure of data, and suspending data transfers to third countries. The administrative fines are discretionary rather than mandatory. They must be imposed on a case-by-case basis and must be effective, proportionate and dissuasive. For further information about possible fines and sanctions, please refer to the website link on this slide. As referred to at the beginning of the webinar, we understand that GDPR can be overwhelming, and this is the reason why we've broken down the requirements into step-by-step eBlasts, each covering a different element of GDPR. We reiterate that we would suggest that you take this approach when becoming familiar with GDPR by working your way through each eBlast and understanding the concept and requirements of that one before moving on to the next. If you work with your clients with any other modalities, then you do not need separate paperwork. All the documents and templates we have discussed are business related. However, please do be aware that the templates that we have issued are for a typical nutritional therapy business, and there may be other issues and concerns that you need to consider regarding any other work you do. We are happy to support all BANT members in their understanding and implementation of GDPR. However, it must be understood that the templates and guidance we have provided will need to be adapted by you to ensure that your own business is GDPR compliant. BANT cannot take responsibility for any member not being GDPR compliant. We very much hope that our guidance notes, templates, this webinar and the web pages that will shortly be added to the GDPR page under professional practice have been useful to you. We will also be compiling a frequently asked questions document based on queries received. Any updates to the BANT templates will be issued via further eBlasts, so please do look out for these. If you have any further queries relating to GDPR, then please do email the BANT Professional Practice Committee at bantpractice@bant.org.uk. At last, done. But don't forget, you will need to review consents regularly and ensure any business changes are reflected in your documents. But for now, you can relax. Thank you.